Welcome to another edition of Work-Life Law with attorney Kate Cerrone. Today we're looking at a new law that's important for Connecticut real estate buyers and sellers to know about, the new release-based cleanup regulations. Kate, what are these new regulations all about?
On March 1st of this year, Connecticut will sunset the Property Transfer Act and replace it with the new release-based cleanup regulations. You may not know what this law entails unless you have been the buyer or the seller of a property that the state considers to be contaminated. There's actually a list that is handled by the Connecticut DEEP of contaminated sites. So it may have been that a auto repair service was operated on that property, which means that transmission fluid was handled, could have been spilled on the ground, or there was a documented spillage. Perhaps maybe there was an oil delivery with a considerable amount of oil that was spilled that becomes a contaminated site. So there have been rules that in the past were handled by the Property Transfer Act about reporting requirements that you had to follow before you could sell or buy a property like that. The way that this has been handled up until now and up until the change in March, there was a presumption that, for example, if you ran a dry cleaning facility or you ran an auto repair business, there was a presumption that your property was contaminated. That could get you on the contamination list with the DEP. There would also be a reported spillage. So if an oil company has come with a delivery and there has been, a spillage of gallons of oil, they are required to report that to the state. You could also make it onto the list if a neighbor, someone that shares groundwater with you, has reported a spillage on your property. Those are different ways that properties have come up on this list of contaminated sites.
What exactly triggers environmental obligations under the new RBCR framework?
So under the old system, as I just mentioned, there were sites that were presumed to be contaminated. So selling or transferring those properties automatically triggered environmental investigations, even if no contamination was present. So if my client was selling a dry cleaning business, then I was going to have to follow all of the reporting rules of the required by the state. Under the new rules, the fact that you operate certain businesses, that alone does not trigger cleanup obligations. So that's actually very good for sellers and buyers. But so the reporting that they require is only going to be required if there's been actual contamination. So this streamlines the deals, but it also shifts more risk onto the buyer. So instead of the buyer just relying upon the fact that every type of dry cleaning business, for example, was going to have to certify that there was no contamination, now you should ask your seller, has there been any spillage? How do you handle your hazardous waste? If you don't get good answers to those questions, then you don't want to have to deal with contamination that's found after the fact, after you already purchased the property. So the onus is more now on the buyer to make sure that they are aware of the practices of their seller before they buy that property.
So let's say there's a transaction. Would a spillage or a contamination, is that something that, like with residential, that a buyer could potentially discover through an inspection process? Or if not, let's say the person buys the property, discovers there has been contamination, is the seller then retroactively responsible for not reporting it? How does that work?
So as a practical matter, what we're talking about now is whether there has been actual contamination. So while that makes deals easier because you're not doing these onerous reporting requirements, because what happens is the state comes and does an investigation and they put you into a phase.
How do the new rules manage different levels of environmental risk?
So if you're under phase 1 reporting, for example, there's a different level of reports that you have to do. You have to hire an environmental engineer who comes out and inspects it. And depending on the level of contamination that the state inspector has found, you have to do these different levels of reporting, and you have to hire this engineer, which is, which can be very expensive. So instead of that being triggered with just any type of a site that the state considers to be contaminated, now we have to show actual contamination before those reporting requirements. And then because what happens when you do all of the required reporting, the state will sign off that there has been remediation. So that's what you want to happen. So if I'm representing a client who is selling a auto repair shop, and we show, okay, there was a certain area of the property where the transmission fluid was disposed. We have done remediation. We have removed the first 20 feet of that soil. We've replaced it with new topsoil. We can guarantee to our buyer now that we are in compliance, that there is no contamination. So if there is a seller who is not doing that sort of compliance, the question now is whose responsibility is it going to be? So it's not clear in the new law as of yet who has the responsibility of disclosing. So as a common sense matter, if there has been a spillage, if there were hazardous waste items that were dealt with back in the 70s and the 80s when the regulations were not as strict, has the seller actually disclosed that? It's really not clear how this law is going to be applied as a practical matter in the actual deal. That is yet to be seen.
How should purchase agreements address these new risks, and what should buyers be doing to protect their interests?
So as an attorney, I would ask the seller's attorney to certify for me the way that the materials have been dealt with and handled. Are there any underground oil tanks? I mean, an underground oil tank, that alone is going to be a contaminated site, in my opinion. But there will be negotiation involved here. So, and very often the other thing that happens is that this property was used as an auto repair shop, I don't know, 20 years ago, and that the new owner has just been storing things. So how far back do you go? How many owners do you have to go back to see if there's been some kind of ground contamination? But one thing is certain, is that once you are the record owner of that property, you now own all of that liability. So if you purchase a property and it has been contaminated in the past, and let's say some metals are showing up in the neighbor's well water, you can't point your finger at the person that sold it to you. It will be your due diligence to ask the required questions at the time of the purchase. So for a seller, if the seller finds itself, it's usually a company that's doing this, it's usually commercial property, selling, let's say they're selling mill property. That happens a lot in New England. And they realize that they aren't really aware of the way that hazardous waste might have been dealt with in the past. If they want to be proactive, and if they have the resources to hire an environmental engineer, they could get a report stating that there has been no contamination, there has been soil testing, there's been testing for contaminants, the local groundwater has been tested, and basically get a sign off from an engineer that this is not a contaminated site. Then, your realtor and your attorney will be very happy with you, because your property will go up on the MLS, it will be advertised to be sold, and everyone will be comfortable with how it is being presented.
Okay, so what risk should buyers be especially aware of under the new system?
I think that there will be a lot of businesses that are cost conscious, and that they will not hire an engineer ahead of time. They will not go seeking whether they are a contaminated site. They will just want to sell the property. And a lot of those will be sold as is, and then buyer beware. So the buyer really should be well educated about what they are taking on. Actually, I had a case with a client who purchased an old service station for cars, and he just thought that it was going to be a cool place to work on his own cars. It had a lift, it had this big area, and he liked to tinker with cars, and this was going to be his retirement hobby. Well, we had to counsel him very closely, and we had to make sure that that seller followed all of the DEP requirements to prove that the site was free of contamination. Both parties wanted to just treat this as, as is purchase. This guy was buying it, for his hobby. He wasn't going to actually operate it, but we were not able to let him conduct that purchase that way. And we had to make sure that all of the regulations were complied with. That is going to be an issue as we go ahead with this new law. So the next question may be, how can your purchase and sale contract protect you if there has been negotiations and you are about to purchase a site that was used for commercial use, that there were things like transmission fluid was handled on the property, there was oil, there were other hazardous waste dealt with on the property, then you can address that in your contract. So you should clearly allocate in the contract who's responsible for the environmental investigations, reporting, cleanup, and costs. If I'm representing the buyer, I am going to want the contract to say that that responsibility is on the seller. I happen to think that that's the right thing to do. However, there may be some meaningful negotiations between the parties where the buyer agrees to take on some of that cost or some of that responsibility, and I would say that the wording and the clauses have to be very carefully drawn so that your contract does what you are intending it to do.
All right, so let's sum it all up. What would you say is the biggest takeaway for real estate buyers with regard to this new law?
You should really think through and put into writing what happens if contamination is discovered during due diligence. So what that means is the seller is saying there is no contamination on the site and it's being sold as is. And then you are, as the buyer, you're conducting your due diligence. Your environmental engineer or your inspector that you've hired to do soil testing does in fact find contamination. If it's already dealt with in the contract, that should that occur, then who bears the cost, who bears the responsibility? You should write that down in the contract just so that it's clear between the parties. So who controls the remediation decisions? So another thing that may happen is that a seller who is trying to cut costs will take the lowest cost remediation possible. Will they take enough layer of soil off and replace it with clean soil? Will they go down far enough? Will they investigate every single site where there's a suspected underground oil tank? So it's a good idea to have that in writing. It's also a good idea to have in there a termination clause that you as the buyer can use if you start to become uncomfortable with the way that the seller is dealing with their contamination remediation. So you shouldn't bind yourself to a contract so that you're blindly trusting another party who may not do all of the costly remediation that is required. You would want to make sure you can get out of a contract if you want to. Now, also from the perspective of a seller, you have to keep in mind that every test that either you conduct or a potential buyer conducts now has to be disclosed to the next buyer. So if you are, you would like to just sell your property as is, your buyer wants a lot of testing done, don't think that that is the only place that those test results will be discussed. So the ethics of selling property, these are ethics rules that real estate agents and attorneys follow, is that there has to be full disclosure of what you have found. So if you have a buyer that has found some contamination, it is in your best interest to work with that buyer and get it remediated, or else it will be a problem that will follow you throughout all of the attempted sales of your property. So the main takeaways, if you are about to sell or purchase commercial property, there is some relaxation to the regulations in the fact that your property may not automatically be assumed to be contaminated. So in that sense, there are less restrictions. However, there is more responsibility now placed upon the parties in a transaction and less on the state. So if you are a buyer, due diligence is extremely important. You want to understand the uses of this property, how it has been utilized in the past. Is there any chance that there has been some sort of soil or ground contamination or hazardous waste that's buried on the property or affecting local groundwater? The more questions you ask, the better. If your seller is not willing to discuss that or give you the information, it's best to move on and try to find a different property. So full disclosure from the seller is going to be more important than ever. It will be probably more costly now as well. So you would want to have your own experts involved to do a full due diligence, including all the laboratory tests that you would want to do, just to be sure that you don't get burdened with property that is now considered to be contaminated, and then you have all the risks and liabilities that go along with that. So these are just things to consider. There are properties like that all throughout New England. Some of them are really worth the purchase, so it's really worth the time and the due diligence to put into those properties. They can become beautiful commercial uses, but just beware, do your due diligence, make sure you have good, solid contracts.
Thanks for listening to Work Life Law. If you'd like to work with Attorney Cerrone, you can reach her at 860-928-2429 or katecerronelaw.com. You can also follow her on YouTube, Facebook, Instagram, and LinkedIn.